Koiki Media bringing the work closer to the steps. Today being the 11th of May 2022. We are still live here at the Federal High Court, Ado-Ekiti. Adjourned, the one representing the Lanomo Dra, tí wọ́n represent wa, wọ́n máa sọ̀kalẹ̀ nsìn, so wá wá sọ ìtó jẹ́ pàtàkì ní inú ẹ̀. Àwọn ọmọ Yorùbá náà ni ẹ̀rí tí gbogbo wa dúró báyìí. We are all many here, in and outside. So no, that's man shit. Okay. Ibi ni lọ́yà tí máa sọ. Iwájú ti lọ́yà tí máa sọ. Ibi tí lọ́yà tí máa sọ. So the case has been adjourned to 20 of this month. So adájọ́ máa jáde wá wá sọ̀rọ̀.
Ẹ kú dìde o, kò ní rẹ̀ yín o, ẹ sì rere kéésì ní agbára Ọlọ́run. Yorùbá nation ó ti wá, ó dẹ̀ máa dúró gbáyìn. Ẹni tó bá sọ pé kò ṣeé ṣe àfi tí ò bá tẹ̀lé ilé àgbè. Àṣẹ. Ẹgbàá ọdún tuntun bọ̀. Ṣé kìí ṣe 13?
No, 17.
17,000. 17,000. 3 days in Tamale.
Wọ́n sì lè máa sọ nǹkan míì bọ̀ not adjournment or
Ká bọ́ síta ní.
17 ni oṣù.
kí máa fi ṣe Òṣogbo máa rán létí Òṣogbo.
Ọjọ́ 17 of this month. Lọ́yà wa ti ń bọ̀ so.
That is our lawyer.
That's our lawyer. The one representing the Lanomo Dra. Share this broadcast if you're watching. A very, very beautiful morning, afternoon, and night to you from wherever you're watching from. Okay, kill
Kílẹ̀ wá ṣe nulẹ̀. No, àwọn Àgbẹ̀kọ̀yà ni sọ pé kílẹ̀ wá ṣe nulẹ̀. Wọ́n lọ kó bọ̀ wọn sínú mọ́tò.
Hello, Baba.
So making it private.
Ekiti ti jẹ breakfast.
Àwọn akọ Yorùbá national anthem níta players ẹ̀rọ adéta náà. Ẹ jẹ́ kí o gbọ́ wọn prepare on the 17th of this month ní Òṣogbo Federal Court. Àwọn wá sí lọ́dún 20th wa Òṣogbo la máa ṣe pàtó tó ṣe ti Èkìtì.
Wọ́n fẹ́ pàtó lórí wọ́n fẹ́ ní kó gbà ìlànà.
Àwọn alọ́kọ̀ ya wọn ẹ̀rú bà wọ́n.
Good morning, sir. Yeah, for purpose of record, let's get to this.
My name is Tolu Babaleye. I'm the lawyer to Omoni and 6 others that are challenging the election of Ekiti.
Okay.
Yes.
So what was the outcome of today's sitting?
Well, we were in court. Even though we serve INEC and the Attorney General of the Federation, they were absent in court as usual. But the problem that the issue was that was raised by court was that yes, you can find out from the record that they have been duly served, but unfortunately, we only served them 2 days ago. And you know, because of between the last adjourned date and now, there has been so many public holidays and weekends. So the best possible time to serve them cannot be later than, cannot be earlier than 2 days ago we served them. But unfortunately, the court mindful of the fact that he wants to do justice to all, has graciously granted them another opportunity and gave order that we should serve them another hearing notice.
Okay.
And we informed the court that the purpose of instituting the matter is to challenge the legality of the Ekiti election, that is to be held under the Nigerian Constitution, which in our considered opinion is a fraud, having lied against itself. The court now opined that is aware of it, and that as long as this case is pending, even if the case could not be concluded before the election is held, the implication is already known under the principle of the Latin maxim that is called ubi jus ibi remedium. That is, when there is a right, there must be a remedy, no matter how long. So the court, mindful of also the fact that the election is coming and the live issue that we raise might become academic exercise, has granted us 20th of May, out of ingenuity of the court, because it is a Friday, but because of the congestion of the court record, we could not get any earlier date. So, and we're even grateful to the court that the court can grant us a short, that kind of short adjournment, and we are going to put on notice Attorney General of the Federation and INEC again before we get to court on 20th. And on 20th, if they are not there, we will address the court, and the court will take decision on the matter.
Sir, considering the time, we are in May, and the governorship election they are being challenged is June 18. Do you think there is enough time, to really get justice?
That is what I've already told you in the Latin maxim, that we raised the issue that the court should be aware that the election we are challenging will be coming up sometime in June. And we are here, and the defendants have not yet appeared in this court. The court now said that as long as we have filed the case before the holding of that election, and assuming that the case did not even will not be concluded before the election is conducted, there is a principle in law that has already anticipated that, and it is called ubi jus ibi remedium. When there is a wrong, there must be a remedy. And as long as we have already put them on notice, they are already aware that a case is pending against the election. If they go ahead and do anything, the outcome of the judgment of that court, if it is in our favor, will automatically nullify the election. Because it means that they ought not to have conducted the election as long as the case is pending under the principle of least pending.
What about the actors involved in the forthcoming election, the candidates? Don't you think they will make attempts to frustrate your efforts?
Well, I don't think so, because they are not necessary parties in this matter. Because Attorney General of the Federation is the chief law officer in Nigeria, and the INEC is the organ conducting election in Nigeria. So they are both federal agencies. And the election we are talking about is not Ekiti state election. It's not election being conducted by Ekiti State Independent Electoral Commission. So we have sued the appropriate people. And whoever feels aggrieved that is supposed to have been joined and we didn't join them can come and apply to be joined. I will tell him that, look, you are an officious intermeddler and interloper. Your attention is not required. You understand? So I do not want to dwell into the sister case that we have in another state. That issue has already arisen and we are taking care of it.
Yeah, thank you very much.
Ẹ ṣé bàbá wa kí ẹ tún bá lọ sà. Àmọ́ ó lẹ́ni fún àwọn ọmọ Yorùbá nípa àmọ́ ó lẹ́ni fún àwọn ọmọ Yorùbá nílé lóko lọ́nà àti lẹ́yìn òde nípa case adjournment yìí.
Well, èmi kàn fẹ́ sọ fún gbogbo ọmọ Yorùbá pé ká jọ ká má bára wa jà. I will be saying it for the up-to-10th time. Pé aláfẹ́ gba Yorùbá nation kì í ṣagídí kì í ṣe ìjà. Tá bá wo kan tí wọ́n ń ṣe ní south east láàrin àwọn Ìgbò, wọ́n bà ìlú wọn jẹ́, wọ́n pa àwọn èèyàn wọn. Tí wọ́n bá tẹ̀ gba Biafra yẹn, àwọn òun náà fẹ́ ṣe Biafra yẹn lé lórí. Ṣèbí ara wọn tán pa yẹn náà ni. Kò síjọ́ tí gbogbo opinion wa lè the same nílẹ̀ Yorùbá. Kò síjọ́ ẹ̀, ṣùgbọ́n kinní kan ló so wá papọ̀ nílẹ̀ Káàárọ̀ Oòjíire. Ọmọlúwàbí la mọ gbogbo wa sí. Ọmọlúwàbí yẹn ló dẹ̀ gbé wa délé ẹjọ́. Nítorí pé ọmọlúwàbí kì í fàjọpọ̀, kì í ṣe jàgídíjàgan. Ikọ̀ tó bá ti tọ́ lọ́mọlúwàbí máa ń ṣe. Civilized people, only civilized people can come to court. And Yoruba people worldwide are the most civilized people in the world. And that is why we are in this court. That is why we have refused to carry weapons. That's why we have refused to go, violent in the pursuit of this self-determination, which is our fundamental right. That is entrenched in our constitution and in the United Nations. Charter of Human and People's Right. So, ọmọ Yorùbá, ẹ jọ̀ọ́, ẹ má jà, ẹ má yẹ ká bà nǹkan ní wa jẹ́, nítorí pé tá bá tẹ̀ dé ilẹ̀ lérí yìí, àwọn kan yìí la máa fi bẹ̀rẹ̀ ìjọba àti ìlú wa. So ẹ jẹ́ ká máa gbàdúrà ká dẹ̀ mọ̀ wípé lábẹ́ òfin àyè wà fún wa láti ṣe nǹkan táwọn ṣe. Ìdí yẹn la fi wà ní ilé ẹjọ́ yìí.
Sà, pẹ̀lú gbogbo èyí tí ẹ bá wa sọ ní èdè Gẹ̀ẹ́sì lẹ́ẹ̀kan, a fẹ́ kẹjọ kẹ́ bá wa dárúkọ yín àti èyí tí a wá ṣe ní ibi ìlẹ́yìn.
Orúkọ mi ni Tolú Babalẹ̀yẹ. Èmi ni lead counsel, nítorí pé àwa márùn-ún ló ṣe ẹjọ́ ìléni, ṣùgbọ́n ẹ̀mọ̀ bí ilé ẹjọ́ ṣe rí ẹnìkan ló máa dànàsì gbogbo orúkọ àwọn mẹ́rin tó kù. Èmi mo ṣáájú ẹjọ́ yìí léni. Kan tó dẹ̀ ṣẹlẹ̀ ni pé àwọn àjọ INEC àti agbèfọ́nba tí a mọ̀ pé sí Attorney General wọn wá sí kóòtù léni gẹ́gẹ́ bí ìwà ti ṣe wọn, nítorí pé wọn wá náà ní kóòtù tó kọjá. Ṣùgbọ́n àtàwọn olólobó